Good morning. It's always a good day when you find out that Donald Trump played himself. He fucking did. That's the way it is. We lawyers would call this pretty standard motion to dismiss an indictment. In this instance, I'm calling it a badass move. What am I talking about? I am talking about a judge in Wisconsin who was doing her job and presiding over her courtroom. And why was she doing this? Because that's her job, right? She is at court overseeing misdemeanor hearings. This was the day when people came in with things, I don't know, sometimes misdemeanors can be traffic related. I don't know if her court handles that, but in this instance, she was handling a misdemeanor of someone who is an undocumented immigrant and found out that there were a bunch of ICE people in uniforms or DHS officers, and they were outside her courtroom swarming around that hallway of the courtroom. Whether if you've been in a courthouse, in this case, whether it's a state or county courthouse, there are benches in the hallway. There are tons of people waiting around. There are families. Someone could be in that courtroom. I'm sorry, in that courthouse because they're dealing with an adoption. Maybe there's a custody battle in some instance. Maybe they're witness in a civil lawsuit. There are all kinds of reasons depending upon what goes on in that courthouse, why people are there. Could be domestic violence. We don't know. And there they could be there because they're suing for police brutality. We don't know, but this is a public space, people getting access to justice. And outside this woman's courtroom, this judge's courtroom, hovering outside there were these ICE agents or DS agents in full uniform. There was one who was in plain clothes. We'll get to him in a moment. And she finds out from her clerk that that's happening. And she knows that in her courtroom, there's a guy who's about to be before her with some misdemeanor charges. I don't remember what they were, but he had showed up for court with his lawyer to answer to those charges, which is what you would want for anyone, including someone who is undocumented here in the US. And he may have been, I should say he's undocumented. He could be here with temporary protected status. I know he's not a US citizen. So there he is in her court. So she's upset that she hears there are people outside there. What are they doing? They're there to try to bring him into custody with a administrative warrant. Now, an administrative warrant is different than a criminal warrant that is signed by a judge. Administrative warrant is something that the agency itself, without any judicial oversight, is going to issue. And we know that what ICE and DHS has been doing when they claim to people we have the right to take you away or get into your home is that they don't follow constitutional standards. And this guy was probably going to be at that moment, and we'll get to this more, but whisked away, maybe locked up somewhere and never see the light of day again because they're not interested, and maybe even thrown on an airplane and sent out of the country to a place he's never been. Family never see from him, could have children, a wife. We don't know anything, but neither probably did the judge about his history. On top of that, let's just talk about what was going on for this particular defendant. On top of that, anyone using that courtroom, that hallway, sees a ton of armed, uniformed agents hovering outside of a courtroom. It creates intimidation. It means if you hear about that, will you show up if you have a traffic issue? Will you come in if you're supposed to be a witness to a crime? Why would you come into a courthouse if you think that could happen? So that's kind of the mindset there. So apparently the judge from there, from what I read, she or the clerk was unhappy and wanted to go speak to the court administrator and either spoke to them on the phone or went to the office. And the bottom line was this is again what I had read in the original complaint. The facts could have changed. Those armed, uniformed officers go to the court administrator's office to speak with them. but this left in the hallway was some plainclothes person, not in uniform. At any rate, so the judge is back in her courtroom. Again, I think that she left, could have been her clerk. The judge is back in her courtroom on the bench, presiding over the misdemeanor hearings, and she called forward or motioned for this man, the non-citizen, who these folks were there to issue that administrative warrant. She motions to him, and he comes up with a lawyer. And if you imagine this, imagine I am the judge, or okay, and here I am on the bench, and imagine the hallway is this way, right? The hallway is that way. And most people come in and out of my courtroom through the hallway that way, right? And here I am facing this way. Here's, you guys are, in the court watching the proceedings. Maybe the jury's to my right, over to my left is the doorway. I motion for them to come forward, or the judge does. They come up, they walk behind where the judge was sitting and into a space. That's the exit the jurors would go. Right. So they walk, I could have them go, I motion them to come up. They walk behind, and there's a door, and that door goes into the jury room. And I actually put it over here. I motion them to come up. They go out this door into the jury room, and then out. Right, the jury room is a little bit down the hallway from the main entrance, and they exit that way. Why is there a separate exit into the public hallway for the jury? So that your jury can leave and go out a side door when you don't have maybe the defendant's family in a criminal case or in a civil case, the plaintiff and defendant's lawyers. You don't want the jury to have to make eye contact or come into any contact with any of the parties, because that could lead to jury tampering, and it could throw the whole trial out, and it would be a miscarriage of justice. It would be chaos. So that is why there is a separate entrance to exit the courtroom for jurors. So she was thinking, you know what? I'm going to have this person go out that same entrance. It's just down the hallway. And it's her prerogative, we will hear, for her to do that. The whole bunch of reasons why. One of them could have been to protect him from this arrest. We don't know. This administrative warrant. Another reason could have been because and not because of him, but if this arrest happened in her hallway, it could create chaos and violence right in the floor in front of her courtroom and in the courthouse. So having them exit farther down, which he did, he and his lawyer, they exit farther down the hallway, they get in the elevator, they walk out onto the street, and guess who is there? ICE. And those agents chased him down the street, tackled him, arrested him, and took him into custody anyway. So that is the story I'm giving you. And as you know, a couple weeks ago, she was arrested, taken away in handcuffs for doing this. And then she was finally charged, indicted by a grand jury. And you may think, well, then she must have done something wrong. Well, let me tell you a couple things. There's an expression that, and this is indicted in a federal court, that grand juries would indict a ham sandwich. That is the joke, that a ham sandwich would be so illegal that it would be indicted. Like, even if it is not sentient, it could be accused of a crime. So here's the deal. As I began here, it's pretty common if you are charged, if you have negotiated a plea, you don't get indicted. It's called an information. But if you have not negotiated a plea and you have been indicted by a federal grand jury, one of the choices that your lawyer has is to file a motion to dismiss your charges. That's what they can do. And there's a thing called there's a set of rules called the Federal Rules of Criminal Procedure. And under these rules, under Rule 12, you can file this motion to dismiss your charges. And so that is what the judges did. And the reason why I say that Donald Trump played himself is I need to, and I'm gonna show you here the language. And I'm going to give you saw this language that I put up. I'm going to read it, and then I'm going to give you the context on the first page, on the very first page here. of this indictment. I'm sorry, of this, the very first page of this motion to dismiss this complaint, this indictment, I should say, against her. On the very, very first page, what did we see? We see a reference to Donald Trump's own case. Yes, absolutely. She nailed him. And so I want to read this excerpt to you and then explain to you why this is so awesome and give you a little more context. What happened here is the judge decided not to address the actual charges in the complaint, which we can talk about in a moment. There's standard charges that I see time and time again in all the federal white collar criminal cases that my students study. Okay. And I believe they are baseless on as applied to her anyway. But why did she not address the actual allegations? Because it made more sense for her and for judges like her to assert a blanket claim of immunity. Does that sound familiar to you? Here we go. The government cannot prosecute Judge Dugan because she is entitled to judicial immunity for her official acts. Immunity is not a defense to the prosecution to be determined later by a jury or court. It is an absolute bar to the prosecution at the outset. And what does she cite? Trump versus United States, 603 U.S. 593, pin site, that means page 630 from 2024. Holy shit. On the first page. What a total badass move. Now, we're going to get a little bit of a legal analysis today of this, but I need to pivot for a moment and give you an update. So guys, yesterday, you remember we were talking about the impeachment, right? We specifically were talking about how Rep. Tander had not just introduced articles of impeachment against Donald Trump about a month ago, but that 2 days ago, he had done this procedural move. Here we go, called a privilege. And I'm going to read this to you again, that his move forced the House to take action by the end of the week unless he withdraws his motion. Okay, so he had until yesterday night to either withdraw his motion or the motion would have gone forward. And today, the full House was going to have to vote to either impeach, not impeach. So they have to vote yes, impeach him on these counts, don't impeach him, or the third choice was going to be shelve this. And what did Tander do? He folded. He withdrew his motion under pressure yesterday. And I am not sure, guys, how I feel about this. I will say the positive thing is we didn't have to see Democrats reject an impeachment. Democrats, in other words, vote to shelve this. But what I don't love about it, and also, I think there is a need to be respectful of the authority and hierarchy of your party. Because let me make the best case and then tell you why I'm still upset. And I think the party might be, it takes a lot. So let's say this didn't get shelved. Let's say there were Republicans who wanted to move forward with this impeachment. Then there would have to be an impeachment trial, which requires preparation. Okay, fine. And then it would move presumably. And then after the impeachment trial, though, it's quite I'm sorry. If they voted, if they voted to to move this forward. And we ended up with this impeachment. Then it would move over to the Senate for a trial. And of course, the problem is, and the chief judge would preside over it. The problem is that it would be run by the Senate majority. And right now, that's John Thune. And how do you think he's going to run that trial? So it's complicated, right? And I can see what a conundrum this would put them in. On the other hand, to have Mike Johnson and the Republicans have any of them defect and vote for Donald Trump's impeachment, that would be kind of amazing. So I guess I'm disappointed because if this vote had been forced through and the Republicans had voted to shelve it, this wouldn't go forward. So I'm not exactly sure what went on here, but there are minds wiser than mine. Tander didn't walk away with his tail between his legs. He instead said, since the time I filed these articles, he's committed more acts that of high crimes and misdemeanors. I'll just keep working on this. Meanwhile, we have Rep. Al Green with his own articles of impeachment that he is, I don't know if he's already offered them. Again, this time around, I don't think he will ever use privilege to force a vote. That's not how he does this. Anyway, so that is where we are. So some people think that the rep in my district filed these articles of impeachment the minute he had a primary challenger in the Democratic primary coming from Justice Democrats. Others, that's a cynical view. But, it is now, whatever happened. And now if it was just a publicity stunt for him and he wasn't serious, he has now walked away. Again, I don't know if I should be disappointed or relieved. I'm mostly disappointed because this is not business as usual. This is horrific what we're going through. And again, let me just say the other side. Maybe they think watching what is happening play out and getting the majority in the Senate, which seems almost impossible, will change things. But we are living under an authoritarian regime where we have a president who is a convicted felon, who is continually committing high crimes and misdemeanors, and even federal criminal offenses for which he is apparently immune. So let's get back to that immunity. Fucking Donald Trump gets to be immune because of the U.S. Supreme Court from almost first of all, anything while he is sitting in office. He cannot be indicted right now. And even after he leaves office, even within the statute of limitations timeframe for nearly anything he does, because he can try to claim it's an official act. If he is indicted, of course, he will make a motion to dismiss of his indictment on the grounds of complete, absolute immunity. So where does that leave us? Well, that leaves us to say, thank God that there is this precedent sitting here, because now this judge is herself going to try to use it. Now, things are a little bit different here. A judge is not a president, right? A judge, this judge is also not a federal judge, but is a local judge. But should that matter? In this case, the arguments are very strong, and they don't go to that issue. I want to pull this up for you now. They go to the 10th Amendment to the Constitution. I bet you haven't looked at that in a long time. So let's go through this. We're going to do a little law school today. Not all 6 pages, but I want to share this screen with you because this is the thing that could save the republic here. I think that you can see this. Okay. So here we have, I've got this. Okay. I think I've got this for you. And I want to show you page by page. This is just the first page. This is the defendant's motion to dismiss this indictment against her, U.S. versus Hannah Duggan. The Honorable Hannah C. Duggan moves for an order dismissing the indictment. This is no ordinary criminal case, and Duggan is no ordinary criminal defendant. Duggan is a Milwaukee County Circuit Court judge. She was arrested and indicted for actions allegedly taken in and in the immediate vicinity of her courtroom, involving a person appearing before her as a party. The government's prosecution of Judge Dugan is virtually unprecedented and entirely unconstitutional. It violates the 10th Amendment and fundamental principles of federalism and comity reflected in that amendment and in the very structure of the United States Constitution. The problems with this prosecution are legion, but most immediately, the government cannot prosecute Judge Dugan because she is entitled to judicial immunity for her official acts. Immunity is not a defense to the prosecution to be determined later by a jury or court. It is an absolute bar to the prosecution at the outset. See Trump versus United States. Now let's go on to the next page. Judge Dugan reserves her right to seek other relief, including by other motions before and at trial. But the immunity and federalism issues must be resolved swiftly because the government has no basis in law to prosecute her. The prosecution against her is barred. The court should dismiss the indictment, and there they cite Rule 12b of the Federal Rules of Criminal Procedure, which allows the court to grant the relief Judge Dugan seeks. Now let's go through. It's not really 6 pages, it's really 5. We're getting through it here, and they're very widely spaced. In support of this motion, Judge Dugan shows 1. The indictment charges Judge Dugan with concealing a person from arrest and obstruction for actions she took in and near her courtroom. The alleged conduct ranges from directing people's movements in and around the courtroom to advising a party that he could appear remotely for his next hearing. 2, the complaint. So note that there's an indictment that's a little skinnier than the complaint. The complaint will flesh it out. The complaint alleges a more cohesive story. In pertinent part, it alleges the following. On Good Friday, April 18th, 2025, Judge Dugan was presiding over her misdemeanor docket in the Milwaukee County Courthouse. So this is where I kind of shared with you those other details. Let me just go to this page. This is key. Even if, contrary to what the trial evidence would show, Judge Dugan took the actions the complaint alleges, these plainly were judicial acts for which she has absolute immunity from criminal prosecution. Judges are empowered to maintain control over their courtroom specifically and the courthouse generally. And they cite a federal decision from the 11th Circuit. And here it is, the issuance of an order removing persons from the courthouse in the interest of maintaining such control as an ordinary function performed by judges. Then they go on to 4. Judge Dugan's subjective motivations are irrelevant to immunity. And here they cite Trump versus United States. Judges are entitled to absolute immunity for the judicial acts without regard to the motive with which those acts are allegedly performed. Now, that is in accord with the Donald Trump opinion. Obviously, that wasn't a judicial opinion. Next, since at least the 17th century in England and carried on through common law in the United States, judges of record have been entitled to absolute immunity for official acts, with a few exceptions not applicable here. 6, Judge Dugan therefore has both immunity from conviction and immunity from prosecution. Okay, what else do we have? As we, I'm just gonna get to another part of this. They kind of go through the various other legal theories that Congress did not abrogate this common law immunity, that it's doubtful that Congress's Article 1 powers would extend to criminalizing the actions of a state court judge. What do they mean here? The statutes that were drawn upon here, the obstruction statute, should not apply, they're saying, to the state court judges. And next, The 9, the problems with this indictment run deeper. Immunities aside, the indictment runs afoul of the of the 10th Amendment and constitutional principles of federalism. What is meant by that? We get to hear. This is key that all other. Okay, so let me just read this to you. The concept in the 10th Amendment is that this enumerates the powers. Sorry, I've got this. I'm gonna get back to the page I was on. Okay. The problems with this indictment run deeper. Immunities aside, the indictment runs afoul of the 10th Amendment and constitutional principles of federalism. Power is limited to specific enumerated areas in the Constitution. Here we go. And this is a 10th Amendment. Okay, so you get the Constitution. It has all the powers laid out. Article 1 is the legislative branch. Article 2 is the executive. Article 3 is the judiciary. We get more powers and we get the amendments that are designed to protect us as citizens, right? So here they're saying, and this is what the 10th Amendment says, right? It's there to protect us. All those amendments, all other powers, quote, are reserved to the states respectively or to the people. So they're saying you cannot do this to a judge. And now 10, the government's prosecution here reaches directly into a state courthouse, disrupting active proceedings and interferes with the official duties of an elected judge. And here they actually quote another Supreme Court decision, McDonald versus United States, which is a case you may know where the Supreme Court acquitted a governor, even though he had taken money in exchange for access from a donor, and they decided that federal statute did not apply because they could not show that he did anything other than introduce the guy to people that he might want to meet, that he didn't. The governor had not engaged in any official act. I have a problem with that decision, but nevertheless, smart to cite it here. And it says, a state defines itself as a sovereign through the structure of its government and the character of those who would exercise government authority. And then 11, as a practical matter, counsel for Judge Dugan stand ready to file briefs and to participate in an evidentiary hearing if either or both will aid the court. But they stand on the observation that any further proceedings in this case, other than immediate dismissal, are barred by official acts immunity and judicial immunity. And then we get to this last page, which I want you to look at. Okay, so in the event this moves forward, Judge Dugan reserves her right to supplement this motion with briefing and other filings submitted within 20 days of arraignment. She has not been arraigned, as provided in Criminal Local Rule 12b1. Okay, what is that about? That is about the fact that she wants to also raise other legal theories for why this indictment should be dismissed as a matter of law. But first, she wants to deal with the immunity issue to make this go away and to protect other judges. Now, I want you to notice here, someone on Blue Sky pointed this out to me. Do you see the name of the law firms representing her? We have one law firm called Strang Bradley and another law firm called Stephen Buskubik Law Office. The lawyers who work for Strang Bradley include Dean Strang. Dean Strang. Do you know who that is? Dean Strang. Dean Strang. Okay. So this is an extremely important case, but I want to point out to you who Dean Strang is. Dean Strang is a lawyer who became famous for the bingeable streaming show Making a Murderer. Yes, he is a well-known criminal defense attorney, and he was in the documentary Making a Murderer. And I think his client was Stephen Avery. This was the man accused of killing a photographer. You may have watched that Making a Murderer show. I think it came out in 2016 pre-COVID, but you might have binged it during COVID. At any rate, she's got an incredible team of lawyers. One last thing on this, and again, I need to emphasize this. I dug into the weeds here for you because we are going to probably see a Supreme Court case in the event that her indictment is not dismissed. And you may say, wait a second. I thought that if you win your case as a criminal defendant, there's no appeal. But this is different. This would be not a trial yet, right? So if this judge that she is before, this federal judge that she goes to ask for the indictment to be dismissed on the grounds of complete blanket immunity, says, yes, Judge Dugan, we agree with you. I agree with you. This case will probably go up to the United States Supreme Court because it's not yet at the trial phase. So we're going to hear more about this. And similarly, if he denies her motion to dismiss, I imagine that she will appeal that. But while she is appealing that, she is going to have to deal with the specific charges against her. So the complaint against Judge Dugan is the complaint against Judge Dugan is also relevant here to us. And I want you to, I'm going to pull this up. I'm having so much fun here. I don't know about you, but I love federal criminal law. And so I'm going to share for you, this will be easier to see, the actual complaint. I know I'm going to share some videos with you today. Don't worry. We're doing something else today because it's important, because I promise you, knowing this, having this foundation will be helpful. Okay, here what I have for you is the complaint, right? And I think someone might want this thrown into the chat here. Here we go. Great. So let's look at, so guys, before I dig into this, I was thinking of having, I don't know, one day a week. I was thinking of having either a spin-off show or one day a week. I mean, I'm already doing law here, but I was thinking, do you think people who were either about to start law school and want to kind of know what is it really about, or do you think you want to be in law school and I have a separate feed where we meet for class once a week and we go over a particular area of law? I don't know. You let me know. Okay, so let's pull this back up, make this a bit bigger here. So I want to tell you here, this is the Dugan complaint. Remember, I told you it accompanies the indictment. So this was the complaint that had been filed that she was responding to. So this is, they're saying that on Good Friday here. So this says U.S. versus Hannah Dugan. And we have on the cover here the complainant's signature. We have FBI Special Agent Lindsay Schlomer signed it, as did this judge, Stephen Dries, a U.S. magistrate judge. And it was sworn on the April 24th. So you can see that here. I'm going to make this a little smaller for a second so you can see kind of the whole thing. The clerk stamps it. What are the two areas of law she was charged with? One is 18 USC 1505, and the other is 18 USC 1071. So why am I throwing these numbers at you? Because I want you to know 18 is the title, kind of like the book. They call it a title, the kind of area. If you think about how it's organized, different titles of the U.S. Code, the United States Code, have different numbers. 18 is where almost all, but not all, of the federal criminal offenses are codified. So they're both in Title 18. USC stands for U.S. Code. Section, okay, what section of it is? Now we're getting down to how it's organized. 1505 is one of the obstruction offenses. And so what was she charged with under that? Obstructing or impeding a proceeding before a department or agency of the United States. And the second one is 18 U.S.C. 1071, which is concealing an individual to prevent his discovery and arrest. So you can see that this is a 13-page complaint, and this is where I was had been referring you to previously, referencing previously about the story of the arrest. Now you may say to me, but Jen, what does 18 USC 1505 have to do with? And that is, as noted, obstruction of proceedings before departments, agencies, and committees. And thank God this particular obstruction statute is pretty small. Now, I'm going to share that with you, but before I do, you can't just read a statute on its own, my friends, and know fully what it means, because you have to also understand how the US Supreme Court has interpreted it. So let me just say the key thing with any obstruction charge, whether it is this one, or like whether it's obstructing an agency or obstructing a court or obstructing the FBI, whatever. Okay, whatever you're applying it to, you need three things. You need an obstructive act. You need a nexus to, or meaning connection to an official proceeding, either in existence or in the offing. And three, you need corrupt intent. So let's look at that statute real quick. And here we go. So this is 18 U.S.C. 1505. And let me just make it bigger. Whoever with intent to avoid, evade, prevent, or obstruct compliance. Okay, let me skip this first paragraph is the antitrust provision. Let's go to the one that applies here. Whoever corruptly, so hold that word, corruptly. That means something really critical here. Whoever corruptly or by threats or force or by any threatening letter or communication does the following. Okay, so let's break this down. Corruptly. So we know she didn't use threats or force. That's not alleged in the complaint. We know that the judge did not send any kinds of threatening letters or communication. So they would have to prove that she acted corruptly. And so far, what we've described, well, first of all, if this is dismissed on the grounds of immunity, we don't look into her motivation or her mindset. Here, corruptly has to mean something particular, a bad intent. Her motivation to not have a melee outside of her courtroom, to not have people trying to serve an administrative warrant outside of her courtroom, that isn't, to me, corrupt. And that's going to be either a question of law, that this will come up. If she doesn't get the immunity, it could come up in the motion to dismiss the indictment, or it will come up before the jury and then on appeal later. So this question is, did she act corruptly? Okay, let's move on. What is the obstructive act? Well, you need her to have to influence, obstruct, or impede. And you might say, wait a second, the guy still got arrested. Okay, hold on, guys. The next part, or endeavors to influence, obstruct, or impede the due and proper administration of law. Okay, so even if she was acting corruptly, did she engage in an obstructive act? Well, did she endeavor to obstruct, influence, obstruct, or impede? Well, she did endeavor to influence, or obstruct, or impede some activity, but was that activity the due and proper administration of law? She would argue that it wasn't, perhaps, right? This is part of a larger process under which DHS and ICE is violating the rights of people who are in the United States entitled to due process, as the Supreme Court said, before they are whisked away and not given any trial or any arraignment or any of their rights, and then sent away. Okay, so the question is whether, first of all, even if you consider that to still be proper, even if you consider that to be the proper administration of law, right? Even if you consider that, given what her mindset was, I also see it wasn't corruptly. Let's move on. Okay, so first, did she act corruptly? We say no. Secondly, did she endeavor to influence or obstruct or impede something? Yes. But was that something the due and proper administration of the law? Here we go. Under which any pending proceeding is being had before any department or agency of the United States. Well, was there a pending proceeding against him? There was a administrative warrant. Okay. And says, or what else could she have been trying to influence, obstruct, or impede, or endeavor to? The due and proper exercise of the power of inquiry. Well, this was not a power of inquiry. Okay. So what will the punishment be? It could be imprisonment of not more than 5 years or more. If it involves domestic or international terrorism, it could be years or both. So that's the max sentence. But the key thing here, I hope that you see in this language, if you're looking at it, that the wiggle room, the space for interpretation is her mental state. Was she acting corruptly? Secondly, even if she was, were the actions that she took to endeavor to influence and obstruct or impede, was there a nexus to her actions and the proper administration of the law? And I would argue no. So you can see how complicated this gets. And these questions of law, some of these are questions of law. As a matter of law, when a judge takes action outside the courtroom, could it be corruptly? There's an issue of law as to whether what they were doing was the proper administration of justice. Was this, that kind of proceeding? But separately, so even if she loses on blanket immunity, and even if she doesn't get the case dismissed because as a matter of law, she wasn't acting corruptly, and if this goes to trial, and if she's convicted, this case isn't going anywhere. Judge Dugan's case, unless even if it is dismissed for blanket immunity, this case is going to be around for a long time. Now, while we're in the soup, you guys, we have to look at 18 U.S.C. 1071. Okay, let's look at 18 U.S.C. 1071, guys. Okay. And can I just say, my show usually has a lot of videos. So for you, if you're joining right now, we don't usually do legal lessons. But whether or not, if you like this, you need to hit like, you need to subscribe, because that's how this universe, this ecosystem works. Okay, let's look at 1071 now. This is also a little tiny statute. Okay, let's share the screen. I'm having fun. I hope you are. Okay, let's look at the other charge. They've also charged her with concealing person from arrest, 18 U.S.C. 1071. I like this. Whoever harbors or conceals. Oh boy, I got a problem here. I got a problem already. So let me tell you, I got a problem. Whoever harbors or conceals. I'm going to drop this in the chat. Harbors or conceals. Let's look at that. So they can throw around concealing the title of this 1071, as you can see, is concealing person from arrest. That's what they call it. But what does the offense specify? What are the elements that a prosecution would need to prove beyond a reasonable doubt? What is the fucking crime, people? You can't just say someone committed a crime without knowing what the words say. Words matter. Let's take a closer look at that. Okay. Whoever harbors or conceals. Harbors. To me, harbor, what does it mean? Not every word is defined. To me, harbor means to keep. It sounds to me like she walked him through the door of her chambers in a jury room, or through the jury room and out into a hallway. That is not harboring. Harboring to me implies keeping for a longer period of time. I have not read the cases on what harboring means, but we are all going to be experts in harboring soon. Harbors or conceals. Did she conceal him? Was he under a blanket? Was he wearing a mask? Did she put him in a laundry basket and cover it and push it down the hallways to the courtroom and put him into a taxi? No. The only question is whether during the short period of time when he exited the public courtroom, went through the jury room, that was 30 seconds at most, and then emerged out into the hallway. Was that 30 seconds or so? I don't have a clock. Does that constitute concealment or not? Okay, now let's keep reading. Whoever harbors or conceals any person whose arrest, a warrant, or process has been issued under the provisions of any law of the United States. So the question was, is this warrant, for whose arrest a warrant has been issued? Now, is a warrant an administrative warrant to take someone into custody, is that considered an arrest or not? And that's the next question. Okay, fine. So if you harbor or conceal, and if that is considered an arrest, so as to prevent his discovery and arrest, she Even if she did, though, she did not present discovery arrest. And after notice or acknowledge the fact that a warrant or process has been issued for the apprehension of such person shall be fined under this title, blah, blah, blah. Imprisonment here can be not more than 1 year or both, except that the warrant or process issued on a charge of a felony after the conviction is more. Okay, so what I'm telling you there is I think she's got very strong legal arguments that she didn't violate that statute either. So now we have been through very general. This would be us. What we just did here was like a brainstorming session. What we would need to do next is know in her jurisdiction and elsewhere how those terms have been defined previously, both harbor and conceal and on and on and on. But you can see what a bad case this is against her. And you might think, damn it, I want to hear her make those arguments. And yeah, that would be cool. However, even though I say there may be law here, is there law involving a judge doing this in her jurisdiction? A judge being indicted? I don't think they're going to find that. So we've got, so much here in terms of interpreting this, but if these would be excellent exam questions because you could make the arguments on both sides. And if students didn't have the opportunity to research both sides, I don't know what the answers would fully be, right? So the bottom line is if I were assigned this case as a defense attorney or you were, I could dole out the assignments so we could figure out exactly what the best cases were for us. But I'm sure that you can see there are questions of law. There are probably questions of fact in dispute. So the very best way to handle this right now is by drawing on the United States Supreme Court decision in Trump versus United States so that they can say she deserves blanket immunity and point to the 10th Amendment, not just for her, but for other judges who could face similar bullshit charges. Okay. So now, whew, I am feeling so frustrated that this judge is having to face this. And I really wish that more people were better educated about what the law says and what it doesn't say, so we can understand how utterly corrupt people like Attorney General Pam Bondi are and how they have no business overseeing law here in the United States. So that brings me to, I have gone on a law school rant. That brings me to a couple things I want to share with you from the news and some great news. The great news is even I last week thought the Genius Act was done and done, but we keep seeing, again, this is about the crypto law, and you made phone calls and you pushed back, and there aren't enough Democratic senators to get this thing through. You need 60 senators altogether, and you need Democrats to get any law like this. It's not a budget bill, right? This is substantive legislation because of the so-called filibuster rule, which is also called cloture, to end the debate, to close the debate on this bill. You need 60 votes. This is not what Republicans have. And so they need Democrats, and they don't have the Democrats. And they will get them if Democrats like, yes, Kristen Gillibrand fold. And it's really disappointing what's happening here. But the good news is we are pushing back, and maybe they won't fold. And I'm going to, tomorrow, this is my big note news. Tomorrow, I am inviting on our show somebody who is an expert in this area. Remember last week when we watched the video Bernie Sanders put forward on Facebook Live, and it had a huge, or was Instagram Live, or both, I don't know, put his video where he interviewed two people, including someone named Corey Freyer. And as part of this discussion, Corey Freyer, who works for the Consumer Federation of America, used to work for Sherrod Brown, used to also advise this the SEC Commissioner Chairman Gary Gensler on crypto. Corey Frayer is going to be joining our show tomorrow, so we can talk about kind of the miracle about this bill. And so I want to be clear with you. This is thanks to people like Elizabeth Warren and people like Indivisible who've told you it matters to push back. And so I want to share with you Elizabeth Warren here. Hold on. Let me just pull this up. I want to share with you Elizabeth Warren talking more about Trump's crypto corruption and how this bill, we need to stop it and at the very least not enable it. People like Kristen Gillibrand don't get that. She's making excuses saying, oh, Trump is going to be corrupt anyway. Let's just get this bill done. Without facing the facts, it's a terrible idea on its face. Okay, so let me share the screen and share Elizabeth Warren with you. I got a few more videos and then crazy town. Here we go.
Just announced that it's pouring money into Donald Trump's pockets.
Oh, sorry. Let me get to this. Sorry. Said that very beginning. Here we go.
A company with ties to China just announced that it's pouring money into Donald Trump's pockets. It said that it's investing as much as $300 million into the president's meme coin. And that's not even the craziest part. The company had about 8 employees on its payroll, and it had 0 revenue last year. So where is this company getting that kind of money? Well, apparently from a stock sale to an unnamed entity in the British Virgin Islands. So we have no idea where this company is getting its money. We have no idea if it's just a shell company for the Chinese government or some other foreign government or company is using it to try to buy off the president. And we have no idea if they're getting something in return for this big investment in Donald Trump personally. It is corruption in plain sight. The former Republican chairman of the House Ethics Committee said out loud what we are all thinking. These foreign entities and governments obviously want to curry favor with the president. That is a direct quote. And he went on to say, this must be addressed. The Senate is at a fork in the road. This week, lawmakers are negotiating the Genius Act, a crypto bill that would turbocharge Trump's crypto corruption. We cannot pass this bill without serious fixes.
That is it. And let's look at the amount of money she said.
A company with ties to China just announced that it's pouring money into Donald Trump's pockets.
Let's look at the numbers.
It said that it's investing as much as $300 million.
Okay. $300 million. I guess that's the entry price point. You got to be in the $100 million range to even get in the door, right? Now that Qatar is giving a $400 million claim, I guess $300 million is kind of in the credible range. Let me explain to you, because I want you to understand how this works. It sounds really fancy, but it's not. Let's just look at this. I'm going to use this. Imagine my little iPod carrier here. That this is the company here. This is Donald Trump's crypto coin company, and this is where they want to collect their money, right? So how does this $300 million get there? Well, she's mentioning that there is, I'm going to use this, it's not really a Sharpie. I think it's it's like a whiteboard dry erase pen. So here's a company, in China, right, that is going to give $300 million, put $300 million into there. She's saying, well, what is this company? It's never had revenue. How do you set up a company in China? I don't know, probably like the US, where you just file some paperwork. Probably there the government has to approve it at the federal level, not just at the state level. So you've got this company in China that's giving $300 million. Where did that company get its money from? Let's use this nice little lipstick here. This company had no revenue. How did it get money? It sold no products. It said, you know what? I want to sell stock to the public. So it sold, I don't know, 300 or more. Let's say just 300 million. It sells $300 million of stock. It says, who wants to buy my stock? We don't make shit. Who wants to buy it? And lo and behold, there's a company that's been set up in the known money laundering haven of the British Virgin Islands, which is a British overseas territory. And yes, the fucking king could do something about this stuff, but nah. So here's this company set up in the British Virgin Islands. Why? Anonymous company. We don't know who the owners are. This company sitting here, this shell company in the British Virgin Islands, someone gave this company $300 million. So all this, we collapse all of this and we look at this. Someone like me, there is a human being, could be someone in the Chinese government, could be a Chinese oligarch. There is a person or a group of people sitting there who have said, how do I give Donald Trump $300 million? I know if I'm foreign, I can't give to his campaign. I don't want to create a lot of attention. So how do I give money to how do I buy his crypto, his really special meme coin or his stable coin? How do I buy that? What if I don't want anyone to see, control, or see my identity? Step one, I open up a company in the British Virgin Islands. Step two, I get funds into my British Virgin Island company, or maybe I already have some sitting there. So I just transfer from one to another. Now no one knows who I am. Step two, that British Virgin Island company then invests in a Chinese company, just hands them the money for not even paper certificates of ownership. Then that company transfers it. I mean, there are many other steps, but the bottom line is it's so easy. These systems are in place. It's so easy to do this. And there is something we can do here to not enable this. Now, of course, Donald's still going to take that money right now, and no one seems to be stopping him. But we don't need to make it easier for him. And that is what this crypto bill would do. Now, I got more for you than Elizabeth Warren. I also have Chris Murphy, and you know how much I absolutely love him. And Chris Murphy, and this is the last thing I'm going to share here. I got one more thing after this, and then after I share this Chris Murphy video and one more, then we're going to get to Crazy Town. Okay, 1 second. So the deal is everybody recognizes this, but we have some Senate Republicans who I don't know why. I don't know who's paying them. I don't know if they feel they're beholden to people in Silicon Valley. I don't know if they don't understand what is going on or if they think you don't understand. But here we go into the money section. I'm trying to grab this. Here is what I'm showing you. Chris Murphy laying that out too.
This crypto regulation bill pending before Congress. The only way we should pass that bill, the only way that we should move that bill forward is if it unwinds Trump's crypto corruption. That would be an example of Democrats saying, you know what, we're not going to pretend that this is business as usual. Unless you are helping us stop Trump's corruption and his attempt to destroy democracy, then we're not moving legislation forward. That's the main thing. That's the problem that we should be solving for. And that's a fight that we're, going to continue to have, a discussion we're going to continue to have.
So remember what's going on here. The Democrats have introduced an amendment to the so-called Genius Bill to stop Donald Trump and his family from profiting off crypto, using it as a way for people to just bribe him, just give him money. And we know that there won't be enough votes to get that amendment into the bill, right? So fuck them. They can't get it in. Why should we pass this bill? What in the world is wrong with people like Mark Warner and Kristen Gillibrand? This kind of bowing down and currying favor with the worst elements of society, who, including Donald Trump, because they're acting like it's business as usual. I was never in favor of her presidential candidacy, but that is another issue. Now, let me share with you my next video. This one will be more cheerful. It is a CNN roundtable, and I'm sorry, I think it's an MSNBC roundtable. Let's play it.
When you were in that same hearing, did you walk away with any new impression of the Secretary of Homeland Security?
So let me back this up. Yesterday, this is where we're getting to Crazy Town soon. There was a hearing where Kristi Noem, head of Homeland Security, was grilled. And it was a nightmare. And it's utterly, utterly shameful what went down. And you're going to hear from Eric Swalwell what his impression was. Let's play that.
Congressman, you were in that same hearing. Did you walk away with any new impression of the Secretary of Homeland Security?
The impression I walked away with was exactly what David just said, which is the secretary and everyone else in the cabinet is completely unwilling to speak the truth to Donald Trump. I focused on the absolute lie that Donald Trump told the public about Mr. Garcia's knuckles, claiming that the letters and numbers MS-13 were actually on his knuckles. And that is so offensive to me, because if the president of the United States is willing to justify someone being detained in a death camp by manufacturing evidence against them, then he would do that to any political enemy of his. He would do that to any American. In due process, the requirement that you bring evidence when you accuse somebody of something, that's what makes us different from China and Russia. That's what makes our country so special. And when he strips that away and no one will speak out against him, we are on the way toward a dictatorship.
I mean, how can you argue with him? He is absolutely, absolutely right. Now, I want to share with you, there was also obviously hearings RFK Jr., but I want to share with you some of the, one other thing from the hearing before I get to Crazy Town. And it is, it's disturbing and it's shameful. And you might remember that among the people who were unlawfully and unconstitutionally whisked away and imprisoned in this gulag, in this prison camp that is essentially for some a death camp in El Salvador, was a young man who Andre, who was either a hairdresser or a makeup artist. And his mother has been asking after him for ages. She wants to know. She has not heard whether he is living, what his conditions are. He's heard none of it. And so as part of yesterday's hearing, we, thank God, had a representative, Robert Garcia, ask about him. And I think that you need to see this. And then we're going to need some Crazy Town, because this is the height of inhumane. It's disgusting. I hope these people can, be tried before The Hague. I think Kristi Noem is the epitome of evil. And I think we knew that, the way she talked about killing her dog. But we're talking about human beings here. And she would treat someone's child the same way that, she would treat something like an animal that she has discarded, her own pet, and worse. This is disgusting, and I want to share with you.
Madam Secretary, is the same that I asked the ambassador. Can we do a proof of life check on Andrew just to see if he is alive?
Congressman, we are utilizing the tools that Congress has given us to apply due process to individuals. We are doing that for every person, and we are making sure that we're following what you have given us as far as guidance and how things should be implemented.
Would you commit to just letting his mother know, as a mother to mother, if Andrew is alive? He was given an asylum appointment by the United States government. We gave him an appointment. We said, Andrew, come to the border at this time to claim asylum. He was taken to a foreign prison in El Salvador. His mother just wants to know if he is alive. Can we check and do a wellness check on him?
Our asylum applications are different than the granting of asylum, and I don't know the specifics of this individual case. This individual is in El Salvador, and the appeal would be best made to the president and to the government of El Salvador on this.
This
is not under my jurisdiction.
Madam Secretary, you have said that CCOT in El Salvador is one of the tools in the toolbox that you have. You have said that and has been quoted as saying that. You and the president have the ability to check if Andrew is alive and if he's not being harmed. Would you commit at least into looking and asking El Salvador if he is alive?
This is a question that's best asked to the president and the government of El Salvador.
And I think you know very well that you could ask that question. What you are choosing to do, Madam Secretary, is disregard this young man's life, this young man's family, who was given an appointment by the United States. I think it is shameful that you won't even request to see if this young man is alive. His family has no idea, has no access to lawyers. I would hope that we would have the humanity to just check if this young man is okay. With that, I yield back.
I don't have words here. This is a lovely man in so much risk as a young gay man in prison. And she doesn't have the dignity, the respect for humanity to even bat a fake eyelash. No tears will smudge her mascara, because this woman, if she has a soul, she ripped it out and sold it long ago in the name of I don't know what, because if she thinks she has power, she does not, because she is essentially a slave to an authoritarian, brutal regime. And I look forward to the day when she is brought down. What an awful monster of a person. How can a mother do that? She is equal to Donald Trump, and she is bullshitting us that somehow she has no contact with the president of El Salvador. This is the woman who posed in front of the prison. You know damn well that if she wanted to ask if that young man was alive, she could get him out of prison like that, and she won't. Imagining having the power to help people in this world and using it instead to harm them. Sadistic and monstrous. Those are the facts. And now, I know I'm carrying over our time, but now I do want to get us to Crazy Town. And Crazy Town is going to be a little more Eric Swalwell. You saw him reference this, but I need you to see it. I need you to see this in person. Crazy Town is Kristi Noem literally refusing to answer a question that's straightforward, whether the Photoshop, the doctoring of tattoos on Kilmar Abreu Garcia was fake. She can't say it. So let's do Crazy Town, because she's not just evil. She's crazy to think that she won't be treated just like these people she is harming. And I do want to say to you, when it comes to this, and where is my Crazy Town? I've lost my Crazy Town music, you guys. Something weird happened with my setup today. And so, friends, I don't have, when I'm in, oh my gosh, I don't have my Crazy Town music. So I think I'm going to just do this and see what happens. No, I don't like that. Oh my God. Okay, I'll fix this. I don't know. Something weird happened when I set up my streams this morning. At any rate, let us just do this crazy shit right now. Here we go.
So that this is doctored, is that right?
The same protocols that are
Madam
applied
Secretary,
to every
I want you to have
individual with law
credibility,
enforcement.
and I want you to be taken seriously. Is this doctored or is it not
Sir,
doctored?
I am taken quite seriously
Is it
because I
doctored
approach
or
my
not
job
doctored?
with the importance that the president has given me to do
I understand.
my job.
Is it doctored or not
One thing
doctored?
that's important to remember is that every single time a case is built.
Madam
against
Secretary, I have a
individuals,
7-year-old,
the
a
same
6-year-old, and a
protocols.
3-year-old. I have a bullshit detector. I'm just asking you, is this doctored or not doctored?
Sir, the protocols in the case built against
Can you
Abrego
answer the
Garcia
question?
were exactly the same.
Madam Secretary,
I don't have
you're-
any knowledge as to that photo you're pointing to.
Okay, can you
I
take her,
don't, sir.
can you show her the photo? Walk her the photo down there. No, that one. Please take a look at this photo. It was tweeted by the president on April 21. It's been hanging out there for about a month.
So what is your point?
Yeah, you know what the point is. The point is to expose you as a toady and a liar and an evil person. And I will fix my tech problems tomorrow, you guys, and I will see you bright and early at 8:30 and at 9 a.m. Corey Frere will be joining us to talk Donald Trump, corruption, crypto, and the so-called genius bill. Love you guys. Bye.